Hello, this is Matt on the Moon Lambeau channel. It is my absolute pleasure to report the shattering defeat of the SEC today, as Judge Torres has ruled that the SEC absolutely must hand over the Bill Hinman Ethereum Free Pass emails and all of the drafts associated with that. This is a massive blow that I think, in all probability, is going to lead to a settlement with Ripple. And I'll articulate why as we go through this. And Attorney John Deaton has said as much in the past, and I tagged him in a tweet. I haven't heard back yet, just wanted to double check to make sure that he still feels that way, but he has previously articulated on multiple occasions that once this moment in time occurs, what just happened today, that starts a 90-day timer, in his opinion, that the SEC and Ripple are going to reach settlement. And not only that, the price of XRP upon this news coming out, my gosh, the price of XRP has just been rocketing. And I'll show you where it's at least at the time that I'm recording this. But before going any further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice. And you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. So I'm going to do what I normally do in videos like this where I cover legal happenings. I'm going to share with you perspective from attorneys within the XRP community, and then I'm going to break down some of the parts that I found most interesting. This document is actually only 9 pages, so it wasn't that bad to get through, and I highlighted the parts that I found most interesting, made a few notes along the way, so you can hear I got the dead trees up in my little Moon Lambeau fingers here. And I do have opinions from 4 attorneys. Now, at the moment I'm recording this, it is 4:58 p.m. Central Standard Time, and this news broke from attorney James K. Filan, member of the XRP community, at 2:44 p.m. So it's been just a little over 2 hours, and I'm sure there will be additional analysis as a result moving forward, but I've already got a ton for you at this point to break down. And so here's a tweet that set it all off from attorney Filan. He tweeted out, "Breaking. Judge Torres overrules the SEC's objections and orders the SEC to turn over Hinman documents." And this set XRP aflying. It was at about 43 cents before the news. Here's the 24-hour chart for those of you that care to look at your screen. You can see it's just like rocket ship. It was briefly over 50 cents. It's a hair below that now. Won't be surprised to see it if it does climb further. It's so fascinating because, look, clearly XRP is not a security of Ripple, but the assertion by the SEC that it is resulted in December of 2020 in the price of XRP plummeting. Just on the assertion. It's not that the rest of the world actually thought that was true, but the SEC said it. What they say carries weight, right? But now, based on what's happened from Judge Torres, this massive smackdown here, and again, it really is a truly shattering defeat, people are feeling a bit more confident that those little bitch asses at the SEC aren't going to have their way in the end, and the price is just flying to the upside. And so I tweeted this out at just about an hour ago, 3:57 p.m. Central Standard Time, and I wrote, XRP up from 43 cents to 47 cents in short order on news of Judge Torres overruling SEC objections regarding attorney-client privilege and DPP. I can only imagine the pump when XRP has legal clarity to the positive. So think about this. If you're talking inside of 2 hours, XRP going from 43 cents to over 50 cents just on this ruling, which is not legal clarity for XRP, can you imagine the rocket ship that XRP will be if we do get positive clarity when this is all said and done? If that happens, my gosh, I can only imagine the degree to which faces will be melted. The whole world just in a frenzy. It will be in a frenzy. There are right now, actually. I mean, you can already see. I mean, it's not that crypto is necessarily looking bad. Like, Bitcoin's okay today, but mostly just kind of trading sideways. So the fact that XRP did this, and right as this ruling came out, not a surprise. Definitely not a surprise. Now, so somebody named Capitano Crypto responded to that tweet of mine from an hour ago that I just shared and wrote, "No third-party promotion," with a couple laughy faces. And attorney Fred Rispoli, a member of the XRP community, responded to that and wrote, "At this point, SEC should really file a request for Judge Torres to recuse herself, as it is clear she is influencing the price of XRP and is therefore, under SEC's theory, a promoter of the token just like Ripple." I love that. I love that. I mean, hell, under SEC logic, that would make sense, right? So I'm going to share with you first what attorney Fred Rispoli had to say. I've got a comment also from attorney Jeremy Hogan, attorney John Deaton also, and then attorney Bill. But I'm going to start here And so just 25 minutes ago, at the time of recording this at least, Attorney Rispoli shared the following thoughts regarding what actually just happened here. And I'm telling you, it is bad. We're talking about sinking ship stuff, but I'll let Fred speak for himself here. Check this out. Hashtag XRP community. Thoughts on a wonderful win. First, although expected given the high burden SEC needed to carry, this win was amazing given Judge Torres was making me sweat, but not Attorney Jeremy Hogan, who called end of September. Second, we have more context of Judge Torres' judicial temperament in this case, and it does not bode well for the SEC. The writing is on the wall, but I'm still not sure if the SEC has the literacy level to read it. I love that. I'm not confident they do either, Fred. I'm really not confident that they do, but they're not good at things, just generally speaking. Anyway, Attorney Rispoli continues. Judge Torres telegraphed how she will evaluate the motion for summary judgment papers and case law, and it's not in SEC's favor. Third, Judge Torres did hint that the document sought, though relevant for discovery, may not actually be admissible for trial. But this is not a major concern because once they are disclosed, the damage to the SEC is done. Judge Torres did not have any harsh language for SEC like Judge Netburn's hypocrisy zinger, but did allude to the schizophrenic nature of SEC's position. Rest assured, the message was sent to SEC that its ship is sinking and it will not be getting many more offers for lifeboats. Fifth, now we see how desperate the SEC truly is. Does it file motion for reconsideration? Interlocutory appeal? Writ of mandamus? SEC can easily drag the email saga out another 1 to 3 months if it wants to, but any negative appellate ruling for SEC will damage all government agencies in the future, not just SEC. I love that. My favorite line, and I retweeted it actually, was rest assured the message was sent to SEC that its ship is sinking and it will not be getting many more offers for lifeboats. That's good. You gotta love. I mean, I'm specifically going to heart that one. I already retweeted the thread and hearted it, but how about that? And then there was this from Attorney Jeremy Hogan. And there were 3 sections you'll see as I get to the part where I do a little bit of a breakdown, because like I said, I highlighted some parts that I found most interesting and relevant. There's 3 portions and that needed to be considered because there are 3 separate rulings. There was one in January with Judge Netburn, then the second one with Judge Netburn was in April, and then the third one was in the beginning of July. And so here's what Attorney Hogan wrote. Judge Torres agreed with Judge Netburn on every single issue related to the Hinman emails. Relevance, check. Attorney-client privilege, check. DPP, check. Some days I'm proud of this profession, smiley face, hashtag turn over the emails. Here's what Attorney John Deaton has had to say, and I'm sure he's going to have a lot more to break down. But he only put out 2 tweets, and the first one was rather brief, but here's the one where he said a little bit more. He wrote, this is why the crypto market should be thankful Ripple is fighting this case. If you add up the legal fees Ripple has paid to finally get a ruling for Judge Torres, it is likely $2 to $3 million, and they still don't have the documents. Next step, SEC asks to certify or mandamus. So, I mean, we'll see here. They could start fighting back. Maybe they do. And also, you know, there's a possibility, like, even if they do start fighting back, that doesn't necessarily mean that there wouldn't be an opportunity for settlement, because what I've learned from these attorneys over the last year and a half plus is that even if your intent is to settle, your front-facing position for a number of reasons, it has to remain the same. You have to keep pushing forward because you don't know for sure if you're going to be able to come to agreeable settlement terms for sure, no matter what side you're on. And so if the SEC, being the little asshat baby back biatchos that they are, if they finally recognize, yeah, okay, fine, we're screwed here, they still have to keep acting as though they're not, because if they have to keep fighting this, they can't acquiesce, they can't position themselves as though this is going to, any settlement agreement would go exactly like they want. So even if settlement's going to come, from what I've seen from the attorneys, expect the SEC to keep fighting as hard as they possibly can, which is to say they expect them to continue acting like petulant children. Then there was this. Oh, yes, I'll read my own tweet because it kind of flows. I tagged John Deaton here. I wrote, in response to Attorney Filan here, shattering defeat for the SEC. Judge rules they must hand over Hinman emails. And then I tagged Attorney Deaton there and said, do you still think this starts the 90-day timer for the SEC and Ripple to reach settlement? And to this point, I hadn't heard anything back on it. But again, from what I've seen, he'd only put 2 tweets out. I haven't seen him respond to anything else to this point. But again, this just happened a little over 2 hours ago. So it's really, thankfully people could read it to this point, including myself, because it was only 9 pages. But even so, there are a lot of people that are still kind of digesting this, and this is a work day for people. So, John Deaton's a busy man. So we shall see. But as far as what I was referencing here in the 90 days, this is the tweet from Attorney John Deaton from April 18th, 2022. And this is one of a number of times he had mentioned this, but he was asked by Irish Red Crypto, do you still see this wrapping up in 90 days, John? Again, that was April 18th this year. Attorney Deaton said, great question. I said I believe the case would settle within 90 days from Judge Torres affirming Judge Nepern's decision. I still stand by that. However, I didn't really consider Ripple insisting on summary judgment without the emails and documents. In hindsight, it makes sense. The emails and documents are most relevant to fair notice. Ripple can win on a strict Howey analysis, and if they do, the court never has to decide whether Ripple received fair notice. I can now see there being no settlement and the parties let the judge decide via Howey. In other words, view the fair notice defense as insurance. It's an issuance policy, I think he meant insurance policy there again, that kicks in if Ripple loses on a Howey application. Thus, I'm leaning on no settlement and a decision by the judge. The timing of a decision depends on how long it takes Judge Torres to decide. So it just kind of depends. That's why it's up in the air, and I was hoping to seek for some clarification. And I'm sure Attorney Deaton's going to have a lot more to say about this, so we'll see. But I will not be surprised, because look, I don't think we're ever going to see those damn emails. I really don't. I don't think that the SEC is going to hand them over. And we'll see. And so even if they drag this out farther, okay, but there's got to be something so damning in there, completely exculpatory, to the point where, because that's why they're fighting so hard. This is insane, the degree to which they're fighting, and they have to know that they're wrong on the legal front. It's like a Hail Mary, effectively. That's what it looks like. Here we have Attorney Bill, who retweeted the great news from Attorney Filan and said, how good it is, James, to wake up down under to see this tweet from you minutes ago and this great decision. If this can't engender a settlement, what will? Exactly. Settlement on the horizon, I'm certainly hoping. And then there's also this from Attorney Bill. There's somebody that named XRP Hutch who wrote, what makes anyone think they will comply immediately? Fat chance I've seen this movie too. And Bill to that said, sure, the SEC's rights to take this further are not fully exhausted, but it ratchets up the pressure on the SEC. Indeed it does. So now let's go ahead and break some of this down. Again, it's only 9 pages, and I just highlighted the parts, the most tastiest of morsels up in this bitch. I'm going to shoot on over to page 2, because page 1, I think, is mostly, and most of page 2, actually, at least half of page 2, was mostly just kind of citing the circumstances of what led to getting to this point. So if you look under the discussion portion right here, there's going to be 3 primary sections. So the first one is legal standard, and in part it reads as follows. A district court may reconsider a magistrate judge's ruling on any pretrial matter where it has been shown that the magistrate judge's order is clearly erroneous or contrary to the law. And I'll just pause to note here. The initial January order, that had to do with DPP, which just stands for deliberative process privilege. So there, just to refresh everybody's memory here, there were privilege claims that the SEC was asserting in order to hide the Billy Boy Hinman Ethereum free pass emails and all the drafts, the speech leading up to that point. And Judge Nepern said, no, you cannot. And again, the legal arguments I've already covered thoroughly on this channel, so I'm only going to dive so deep into it insofar as it's covered by Judge Torres within this article. But Judge Nepern said, no, that doesn't apply. You need to hand this over. And obviously, you're listening to this now, you already know the judge ended up agreeing. And then there was something also having to do with DPP, and there were additional assertions made by the SEC in April. And then it was in July where the ruling came down from the third ruling from Judge Nepern saying attorney-client privilege does not apply to these circumstances here. So they got, over the course of over half a year, they just continue to get bitch smacked down by Judge Nepern, but they just kept coming back and coming back and coming back. And that's why everybody's saying, what is in these damn emails that you guys are being like this ridiculous? The SEC's bad on every front in this case, fine, but they're taking it to a whole nother level right here. They're fighting ridiculous. It's so obvious there's something in here. They're not acting in good faith in accordance with the rule of law. They are being hypocrites, as Judge Nepern ultimately pointed out. What is in these damn emails? Anyway, so Judge Torres continues and says, a decision is clearly erroneous when the court is, upon review of the entire record, left with the definite and firm conviction that a mistake has been committed. A showing that reasonable minds may differ on the wisdom of granting the defendant's motion is not sufficient to overturn a magistrate judge's decision. It is well established that a magistrate judge's resolution of a non-dispositive matter should be afforded substantial deference and may be overturned only if found to have been an abuse of discretion. Folks, did you hear that? There would have to be a abuse of discretion for it to be overturned. Thus, the party seeking to overturn a magistrate judge's decision carries a heavy burden. So the SEC effectively claimed that Judge Nepern abused her power. Not a fun place to be in. Not a fun place to be in, right? And then check this out. Under application right here, I'll highlight that for the folks looking on the screen. That's where I'm starting now. The SEC objects to the orders, arguing that Judge Nepern erred in, number one, determining that the internal speech documents are relevant to any claim or defense in the case, two, finding that the DPP does not protect the internal speech documents, and three, concluding that the attorney-client privilege does not protect the internal speech documents. The court shall address these objections in turn. Now, I want to pause to note here, and I know this only because I've read a bunch of stuff from attorneys within the XRP community for almost 2 years at this point, frankly. I mean, come on, December, we're at the 2-year mark. And so I've learned that judges here, especially in a situation like this where two judges are working on the case, you got a magistrate judge, Nepern, who is working with, the discovery stuff and everything along those lines. It's pretty common from what I've read from the attorneys within the XRP community that in such circumstances, these judges know each other. They're basically coworkers. They're talking to one another about this stuff. It's not that, because look, they're divvying up the workload. That's why this is happening, right? So it's not that Judge Torres is taking the same in-depth look that Judge Nepern is, but on a broader, like a higher level, just having casual conversation. We don't know for sure if that's occurred, but it's been expressed, and I understand at this point that that's very normal for stuff like that to occur. So think about this. While they're saying that effectively, because they have to argue that Judge Nepern was abusing her power, understand that Judge Torres may have helped Judge Nepern come to these conclusions in the first place. So effectively, in a way, it could in part possibly be the case that the SEC is arguing that Judge Torres came to an inappropriate conclusion. In a roundabout way. You see what I'm saying here? Just something to consider. So now here, under the Section A, relevance, the court, here we are, yeah, it starts here. The court agrees with the SEC that non-public documents, like the internal speech documents, are not directly relevant to any claims or defenses in this case. Internal documents do not bear on the notice parties received or whether the individual defendants knew certain facts about Ripple's offers and sales of XRP. But Judge Nepern did not find that these documents are directly relevant to these issues. Instead, in order to, Judge Nepern declined to take a narrow view of relevance in the context of discovery, and found that these documents are relevant under the extremely broad concept of relevance used to resolve discovery motions. The court holds that, make sure I'm scrolling down for everybody looking. The court holds that Judge Neprin's conclusions regarding the relevance of the internal speech documents are not clearly erroneous or contrary to law. As she noted in Order 2, relevance for purposes of discovery is an extremely broad concept. And if you look at the bottom here, and here's the glorious part, therefore, the SEC's objections to Judge Neprin's findings with respect to the relevance of the internal speech documents are overruled. And I love having that in all caps. I know that's common practice for something like this, but I just want to say it louder because it's in all caps. So I'll do that because it's my channel, damn it, I do what I want. So Judge Torres agrees with Judge Neprin that under existing law, the possibility that the Hinman emails might be relevant means the SEC must hand them over. There was not a narrow view, it was broad, and so under the law, they must be handed over. The SEC was wrong on their understanding, or their alleged understanding of the law, because I don't think they believe what they're arguing, but, you know, it is what it is. Like, these are not good people. Next, Section B here. Deliberative Process Privilege, DPP for short. In addition, the SEC objects to Judge Neprin's determination in the DPP orders that, number one, the internal speech documents are not protected because they reflect Hinman's personal views, and two, the speech was peripheral to SEC policy information. And then a little bit lower, just right here. Come on, click it. There we go. Judge Neprin determined that the DPP does not apply to the internal speech documents because those documents were intended to facilitate the communication of Hinman's own opinions regarding the application, application of the securities laws to digital asset offerings and not the opinions of the SEC. The SEC argues that Judge Neprin's conclusion constitutes an error of law because Second Circuit precedent states that subjective documents, which reflect the personal opinions of the writer rather than the policy of the agency, are protected by the DPP. But this argument fails to recognize that documents reflecting such personal opinions are protected only when they relate to some form of agency position, decision, or policy. Because Judge Neprin determined that the internal speech documents did not relate to any agency position, decision, or policy, her conclusion is not contrary to the law. Right there. See, this is what the SEC was doing. They were making arguments, but they weren't in accordance with precedent that has been set within law. It's clear. So I've covered it, and leading up to this point, it's just nice to see it affirmed by Judge Torres. It's that big of a deal. And so then if you go to, I'm scrolling down here, scroll, page 8. Here we go. Here's the money shot right here, my friends. Therefore, the SEC's objections to Judge Neprin's findings with respect to the SEC's assertions of the DPP are overruled. There we go. It's good. It's cathartic, is it not? All right, and then the third section here, attorney-client privilege. Let me go. Oh, yeah, here we go. All right. This is going to bring it on home here. I love this. I absolutely love this. Starts right here. Okay. Documents are protected by the attorney-client privilege if the predominant purpose of the communications is to render or solicit legal advice. After reviewing the relevant documents and considering the SEC's arguments, the court is not left with the definite and firm conviction that the internal speech documents contain communications with the predominant purpose of interpreting and applying legal principles to guide future conduct or assess past conduct. Therefore, the SEC's objections to Judge Neprin's findings with respect to the SEC's assertions of attorney-client privilege are overruled. The court has reviewed the remainder of the thorough and well-reasoned orders for clear errors and finds none. Accordingly, the court overrules the SEC's objections and directs the SEC to comply with the orders. Conclusion: for the foregoing reasons, the court overrules the SEC's objections and directs the SEC to comply with the orders so ordered. Suck it, bitches. There we go. SEC, bring it what you got now. Now, we knew this was coming, though, didn't we? It was a virtual certainty that this was going to be the end result. And Judge Torres certainly did not disappoint. Because again, even for the layperson, like I don't have a legal background, but for the layperson, just look at the facts and circumstances, getting spoon-fed legal precedent by people who are lawyers, which is what we all need for all of us in the community who are not attorneys. And so it makes it easy to understand. It became crystal clear that the SEC is just not acting in accordance with the rule of law. They're just not. So this is not surprising in that regard. So then the question again, it goes back to the fun stuff is, like, settlement win. Like win settlement, win moon, win Lambo. Friday, 2 p.m., my friends. We shall see. So let's check a price update here. Okay, it's about the same here. 49.7 cents XRP. So I don't know if it's going to go any higher. That could have been it. But again, even if that's it, and I'm not saying it is, maybe it does go higher. But even if this is it, the pump just brought us to a little over 50 cents. This wasn't settlement. It happened with an order. It goes to, right or wrong, it goes to show the degree to which this is resulting in people who are filing the case becoming confident that the SEC is going to lose this thing. And I still don't see how they win. Like, even if there's no settlement, and fine, maybe there's not. Don't know for sure. I'm still betting on a settlement, but even if not, like, even if it takes, there will be appeals and stuff. I get it, no matter who wins. The SEC's wrong. They're just clearly, unquestionably wrong. That's why it's so hard to find attorneys outside of the SEC that will argue that Ripple's in the wrong, that the SEC's right. It's so hard to find that. So this is a great day. I hope you're feeling fantastic. I'm going to go ahead and wrap up here. Please let me know what you think. Drop a comment in the comment section below. That's where they belong, damn it. But I'll wrap up. I'm not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.